Esteemed dignitaries, distinguished guests, respected colleagues, ladies and gentlemen, namaskar and good evening. With great pleasure and immense gratitude, I, on behalf of ILI Assam Unit, welcome you to this prestigious law lecture organized by the Indian Law Institute, Assam Unit. On this significant occasion, it is important to acknowledge the pivotal role played by the Indian Law Institute in the promotion of legal education, research, and dissemination of knowledge in our country. Since its inception in April 2006, ILI Assam Unit has successfully organized numerous seminars, lectures, training programs, and similar events, fostering intellectual growth and professional development. In the recent past, ILI Assam Unit has had the privilege of organizing a law lecture, and we were fortunate enough to have the presence of Honorable Mr. Justice B.R. Gauhati, Judge, Supreme Court of India, as the esteemed speaker. Today's lecture is yet another step in the direction of advancing legal education and research, bringing together legal luminaries and scholars to engage in thought-provoking discourse on issues of great significance. As we gather here for this prestigious law lecture, we are honored to have with us today Honorable Mr. Justice Abhay Srinivas O, Judge, Supreme Court of India, as our chief guest. I request Mr. Mayank Sahiwala, Advocate, Gauhati High Court, to kindly escort Honorable Mr. Justice A.S.O. to the dais. A warm welcome, Your Lordship. We are privileged to have amongst us today Honorable Mr. Justice Ujjal Bhuyan, Judge, Supreme Court of India, as our special guest. I request Mr. Amit Goel, Advocate, Gauhati High Court, to kindly escort Honorable Mr. Justice Ujjal Bhuyan to the dais. A warm welcome. We are grateful to have with us Honorable Mr. Justice Vijay Bishnoi, Chief Justice of the Gauhati High Court and President, ILI Assam Unit. I request Mr. Nayanjyoti Gogoi, Advocate, Gauhati High Court, to kindly escort Honorable Mr. Justice Vijay Bishnoi to the dais. We are humbled to have amongst us Honorable Mr. Justice Soumitra Soikia, Judge, Gauhati High Court, and Executive Chairman, ILI, Assam Unit. I request Mr. Jeremy Lotha to kindly escort Honorable Mr. Justice Soumitra Soikia to the dais. We extend our sincere and cordial welcome to all our dignitaries on the dais, as well as our honorable judges of the Gauhati High Court in attendance, esteemed law officers, revered senior advocates, and other members of the bar, distinguished academicians, students, and everyone present here today. We are truly grateful to have you here. We would now like to proceed with our program by felicitating our esteemed dignitaries on the dais as a mark of gratitude. It is indeed my distinct honor to introduce our distinguished speaker and chief guest of today's event, Honorable Mr. Justice Abhay Srinivas O, Judge, Supreme Court of India. Honorable Mr. Justice A.S.O., Judge, Supreme Court of India, enrolled as an advocate on 20th June 1983 and started practicing in the District of Thane and subsequently in the Bombay High Court. Honorable Mr. Justice A.S.O. was elevated as additional judge of the Bombay High Court on 29th of August 2003 and as permanent judge on 12th of November 2005. Your Lordship was appointed as Chief Justice of the Karnataka High Court on 30th April 2019. Honorable Mr. Justice A.S.O. was elevated as Judge, Supreme Court of India on 26th of August 2021. With an illustrious career marked by decades of dedicated service, Honorable Mr. Justice A.S.O. has consistently exemplified legal excellence and integrity. Amongst his lordship's prominent judgments, the one passed in case of Javed Ahmed Hajam versus State of Maharashtra remains as a defining precedent, wherein the division bench of the Honorable Mr. Justice A.S.O. and Honorable Mr. Justice Ujjal Bhuyan observed that if every criticism or protest of the actions of the state, such as criticizing abrogation of Article 370 on WhatsApp status or wishing independent state of Pakistan, is to be held as an offense under Section 153A, democracy, which is an essential feature of the Constitution of India, will not survive. The right to dissent in a legitimate and lawful manner is an integral part of the rights guaranteed under Article 19(1)A of the Constitution of India. More recently, in July 2024, another landmark judgment was passed by the division bench of Honorable Mr. Justice O and Honorable Mr. Justice Bhuyan in the case of Frank Wittis versus Narcotics Control Bureau, wherein his lordships addressed the legality of bail conditions and held that requiring an accused to share his or her Google location PIN with the investigating officer to enable tracking of movement is a violation of the right of privacy guaranteed under Article 21 of the Indian Constitution. It is with profound respect and deep appreciation that we extend our highest felicitations to Honorable Justice Mr. A.K.O., Judge, Supreme Court of India. May I now request Sri Gajanan Sahibwala, Senior Advocate, Gauhati High Court, and Secretary ILI, Assam Unit, to kindly come up on stage and felicitate Honorable Mr. Justice A.S.O., Judge, Supreme Court of India, with a Fulam Gamusa, shawl, and a token.
Hello.
Thank you, sir. We are greatly privileged to have with us today Honorable Mr. Justice Ujjal Bhuyan, Judge, Supreme Court of India, as our special guest. Marking the beginning of his legal career, Honorable Mr. Justice Ujjal Bhuyan enrolled as an advocate on 20th March 1991 with the Bar Council of Assam, Nagaland, Meghalaya, Manipur, Tripura, Mizoram, and Arunachal Pradesh, while appearing in various significant cases throughout his illustrious career as an advocate. Elevated as an additional judge of the Gauhati High Court on 17th of October 2011, Honorable Mr. Justice Bhuyan was confirmed as permanent judge on 20th of March 2013. Honorable Mr. Justice Bhuyan was sworn in as judge of the Bombay High Court on 3rd October 2019. His Lordship was sworn in as Judge Judge of the Telangana High Court on 22nd of October 2021. Honorable Mr. Justice Ujjal Bhuyan was elevated as a judge of the Supreme Court of India on 14th of July 2023. Through his unwavering dedication and commitment to justice, Honorable Mr. Justice Ujjal Bhuyan has set a standard for fairness, integrity and impartiality in judiciary. With vast experience and profound knowledge, Honorable Mr. Justice Bhuyan has been a guiding force in upholding justice and legal excellence. Recently, while delivering a landmark judgment in the case of Ajay Malik versus State of Uttarakhand, the division bench of Honorable Mr. Justice Suryakant and Honorable Mr. Justice Ujjal Bhuyan observed that there's a legal vacuum which exists vis-a-vis the rights and protection of domestic workers, further directing the Ministry of Labour and Employment to jointly constitute a committee comprising subject experts to consider the desirability of recommending a legal framework for the benefit, protection and regulation of the rights of domestic workers. With each such ruling, your Lordships has demonstrated a profound understanding of law, ensuring justice, not just administering but also delivering with compassion and equity. We are greatly honored and privileged to have you amongst us here. I would like to request Sri Hemanta Kumar Sharma, Advocate Gauhati High Court and Joint Secretary ILI Assam Unit, to kindly come up on stage and felicitate Honorable Mr. Justice Ujjal Bhuyan, Judge Supreme Court of India, with a Palam Thank you, Roshan. Thank you, sir. As we extend our heartfelt felicitations to our esteemed dignitaries, it is both an honor and a privilege to acknowledge a distinguished luminary in the field of law and justice, whose commitment to the advancement of legal education and pursuit of justice are truly commendable. We are fortunate to have Honorable Mr. Justice Vijay Vishnoi, Chief Justice of Gauhati High Court, as the esteemed President of ILI Assam Unit. Honorable Mr. Justice Vijay Vishnoi was sworn in as the Chief Justice of the Gauhati High Court on 5th of February 2024. With extensive judicial expertise and deep scholarly insight, Honorable Mr. Justice Vijay Vishnoi has played a pivotal role in shaping legal discourse and strengthening the judiciary. His Lordship's leadership and guidance reinforces the significance of the institution's endeavour to fortify and advance legal education in the country. I would like to request Sri R.K. Devu Chaudhary, Advocate Gauhati High Court and Life Member ILI Assam Unit, to kindly come up on stage and felicitate Honorable Mr. Justice Vijay Vishnoi, Chief Justice of the Gauhati High Court and President ILI Assam Unit. Thank you, sir. We are grateful to have with us Honorable Mr. Justice Soumitra Soikia, Judge, Gauhati High Court and Executive Chairman of ILI Assam Unit, whose invaluable contributions have strengthened the Institute, fostering academic excellence, legal research and professional growth. We are privileged to have his guidance in shaping the future of legal education. I would like to request Sri Tanmay Mohanto, Advocate Gauhati High Court and Life Member ILI Assam Unit, to kindly come up on stage and felicitate Honorable Mr. Justice Soumitra Soikia, Judge Gauhati High Court and Executive Chairman of ILI Assam Unit, with a Palam Gamusa and a shawl. May I now request Honorable Mr. Justice Vijay Vishnoi, Chief Justice of the Gauhati High Court and President ILI Assam Unit, to kindly deliver the welcome address.
Honorable Mr. Justice Abhay Srinivas Bhuk, Judge Supreme Court of India, Honorable Mr. Justice Ujjal Bhuyan, Judge Supreme Court of India, my esteemed sister and brother judges of Gauhati High Court, Honorable former judges of Gauhati High Court, Advocate General of Gauhati, Mr. G.N. Sahewala, Learned Senior Advocate and Secretary to the Assam State Unit of ILI and other learned members of the ILI Assam Unit, the Bar Association President Mr. Chaudhary, respected senior advocates and all other learned advocates present here, learned judicial officers present here, members of the registry, ladies and gentlemen. Namaskar, a very good evening. Today is a memorable as well as a proud occasion. In the annals of the Assam State Unit of ALI, as we have amidst us, Honorable Mr. Abhay Srinivas, Judge Supreme Court of India, to deliver a lecture before this august gathering of legal luminaries. His Lordship's commitment towards the strengthening the roots of the judiciary to ensure independence of the judiciary is known all across the judicial landscape. However, I would like to briefly say a few words about his Lordship. Honorable Mr. Justice Abhay Srinivas was born on 25th of May 1960. After completing legal education, Lordship started his practice in Thane District Courts. Lordship was elevated as Additional Judge of Bombay High Court in the year 2003 and took oath as the Chief Justice of High Court of Karnataka in the year 2019. His Lordship took oath as a Judge of Supreme Court of India on 31st of August 2021. His Lordship's disciplined life as a lawyer and as a judge speaks volumes of his Lordship's unwavering commitment towards upholding the rule of law and constitutional values, more particularly safeguarding the rights of the weaker sections of the society. This commitment resonates across all judgments delivered by his Lordships. We sincerely express our gratitude and indebtedness to his Lordship for taking trouble to grace this occasion despite his Lordship's busy schedule. With a deep sense of gratitude and privilege, I, on behalf of the Assam State Unit of ILI, extend a heartiest welcome to his Lordships. We are honored by his Lordship's presence. The Assam Unit of ILI Institute was constituted in May 2006. However, due to COVID-19 pandemic situation and also due to some unavoidable circumstances from some time, no major activity was being carried out by this unit, and therefore we decided to initiate activities by lecture series on the legal topics. Last year, we have privileged to welcome Honorable Mr. Justice Bhushan Ramakrishna, Gauhati Judge, Honorable Supreme Court of India, to deliver a law lecture in an event organized by us. In that event, Law Journal 2024 Part 1 of Assam State Unit was released by his Lordships. The Law Journal contained scholarly articles on various legal issues contributed by the members of the ILI. Needless to say, his Lordship's speech on the topic Art of Advocacy and Duties of the Advocates and the Constitution of India in today's law lecture event will inspire and motivate learned advocates to work hard for the right of common people. Further, his Lordship's views and ideas have always been an inspiration for us to strive harder towards achieving the prime objective of Indian Law Institute, that is to cultivate and promote the science of law and to contribute substantially in reforming administration of justice so as to meet the socio-economic aspirations and need of the people through law and its instrumentalities. I have no doubt in mind that today's lecture will set a momentum for a healthy discourse on various issues relating to advocacy, which I hope will act as a catalyst to encourage legal research. This is the basic objective behind the initiation of law lecture series undertaken by ILI Assam Unit, and today's event is a part of this initiative. We are also fortunate to have with us Honorable Mr. Justice Ujjal Bhuyan, Judge Supreme Court of India, who needs no introduction to us. As a lawyer, as well as a judge of Gauhati High Court, Bombay High Court, Chief Justice of the State of Telangana, and then as a judge of Supreme Court of India, his Lordships has contributed immensely to develop the legal course amongst the legal fraternity. His Lordship's unwavering commitment for betterment of judicial structure and its functioning is a source of inspiration for us. I, on behalf of Assam State Unit of ILI, extend a heartiest welcome to his Lordships We are indeed privileged to have your lordships amongst us. I also extend my cordial welcome to my esteemed brother and sister judges of Gauhati High Court who have graced this event in spite of their busy schedule and whose support has been very encouraging. I also heartily welcome the former judges of the Gauhati High Court. I also extend my cordial welcome to the representatives and office bearers of the Bar Association, the learned advocates and other learned advocates who have attended the event in such a large number. Your presence itself emboldens our resolve to achieve our set goals. I heartily welcome learned Grade 1 Judicial Officers of Kamrup Metro and Kamrup. District Judiciary has always been a strong pillar of the foundation of administration of justice. Last but not the least, as the President of UNIT, I also extend my heartiest welcome to the Executive Chairman, Honorable Justice Mr. Sumitra Sekia and other team members of the unit, without whose dedication and support it would not have possible to march ahead with the activities of the ILI. Once again, on this memorable day, I, on behalf of Assam State Unit of ILI, extend a very cordial welcome to all the respected invitees. Jai Hind, Jai Bharat.
Thank you, Your Lordships, for your eloquent welcome address. Your words have set the tone for the event, providing us with a profound sense of direction and enthusiasm for the proceedings ahead. May I now humbly request Honorable Mr. Justice Ujjal Bhuyan, Judge Supreme Court of India, to kindly enlighten us with his speech.
My esteemed senior colleague in the Supreme Court, Justice Oak, the Chief Justice of the Gauhati High Court, Justice Saikia, and all the judges of the Gauhati High Court, former judges of the High Court, President of the Bar Association, my former neighbor, one of the senior most lawyers of the Bar Association, Bhattacharya, the Advocate General, Advocate General of the State of Assam, he is also the Secretary of the HCBA, distinguished senior advocates, ladies and gentlemen. The last 2 days has been really, I would say, very invigorating for me. On Monday, we had a meeting of the National Law University. The Honorable Chief Justice, as his Chancellor, has been kind enough to constitute a core committee to look into various facets of the National Law University and how to take it forward. There are many shortcomings established in 2011. Many NLUs have come up thereafter. Now we have 28 NLUs all over the country. Each NLU is competing with each other. So we need to keep that in mind and look forward. And certainly with the cooperation of everybody, we will be able to take the NLU to the next level. Yesterday, then we had gone to the NLU, where Justice Oak spoke to the law students that advocacy in the trial courts, in fact, are part of the constitutional framework, and advocacy in the trial courts is no less than advocacy before the High Court and the Supreme Court. So it was a very nice experience interacting with the students. Then we had another meeting with the judicial officers belonging to the state judicial service as well as the other states under the Gauhati High Court. Justice Oak, as the Chief Justice of Karnataka High Court, had issued an order saying that trial courts should not be referred to as lower courts or subordinate courts. They should be referred to as trial courts or district courts. We followed that in Telangana, and while sharing a bench, we have passed a judicial order that lower court records should not be referred to as such. Instead, it should be referred to as TCR, trial court records. Because trial courts are the courts of first instance, whether a litigant public, a citizen of this country, comes face to face with the judiciary. That is the face of the Indian judiciary. Very less percentage of people can afford to come to the High Court, not to speak of the Supreme Court. Therefore, our focus should be on the trial courts. In fact, for the trial judges, I may mention that two of India's greatest judges, they are not from the bar, they are from the service. Justice H.R. Khanna, he had practiced in the Amritsar District Court. This is pre-partition days. And the district and session judge, sir, that time it is called the district and session judge. In Maharashtra it is called principal district and session judge, was Mr. Cornelius. It so happened that after partition, he opted for Pakistan, Cornelius and district. And in due course of time in 1960s, in the 60s, he became Chief Justice of Pakistan. And it was he, in one of his judgments, developed the concept of the basic structure, which was thereafter elaborated by Justice Mulholkar and finally in the Keshavananda Bharati case. So, back to Justice Khanna, then he was selected in Grade 1 Judicial Service and posted as a district and session judge in Firozpur. And the rest is history. We have Justice Ahmedi. He started off as a civil judge junior division in Gujarat Judicial Service and rose to become the Chief Justice of India. So I am giving these examples that you need not necessarily be a lawyer practicing in the High Courts or the Supreme Court to rise to these heights. Today we went to the bar and it was a very nice interactive session, very productive interactive session. And we have highlighted the need for a strong independent bar to uphold the independence of the judiciary, which is not only a basic feature of the Constitution, one of the basic features of the Constitution, but the very essence of our democratic republic. And to keep the judiciary strong and independent, a strong and vibrant bar is the need of the hour. We spoke various instances across the country. And finally now, we are in this Indian Law Institute meeting. I remember it was in 2010 when Justice Lokur was here. Justice Lokur was here. We had this meeting of the Indian Law Institute. I was also present here. Of course, thereafter I left. It's nice to see that under the stewardship of Chief Justice Bishnoi and Justice Saikia, the Indian Law Institute is being revived. Well, as a judge of the Supreme Court, I can say Supreme Court is supreme because there are no courts above the Supreme Court. But it is therefore it is not correct to say that judges and the judgments of the Supreme Court are not infallible. Had there been any other court above the Supreme Court, I'm afraid there could have been many different views on the judgment's part. My idea of saying this is this, that we should develop a critical mindset and not to accept, not to lap up any judgment rendered. Today, Justice Oak had also said that we need to have a analysis of these judgments critically. We don't, of course, we have to assign reasons. Why this judgment is not this way? Why this judgment is not this way? And of course, we all know where to draw the line. So therefore, I would humbly request the members of the Assam State Unit of the Indian Law Institute to take out some of the recent judgments. The recent, for example, the recent judgment in Sabrimala needs to be debated. Then again, the attempt to review, which is pending, that again needs to be examined whether the review can be confined only to the points arising out of the valid judgment or it can be expanded. I remember Fali Naringman and many others had taken a serious objection to that. So these are issues which needs to be debated. Then the economic EWS quota, economic review sections quota, 5 judges played. Many say Professor Mohan Gopal was so agitated about it. This again needs to be discussed and debated in a structured way under the forum of the Indian Law Institute. The Ram Janambhoomi judgment, has there been any analysis of these judgments? I really doubt whether there has been any serious attempt to examine the jurisprudential value of these judgments. There can be any number of things. So this platform of ILI should be creatively utilized. I will request Justice Sankhya to call for the views of the members, seek their views, and there can be a decadal analysis, 50s, some of the judgments. The other day we were in Maharashtra National Law University, Aurangabad, both Justice Oak and myself, we were there. Then in that, the main speaker was Arvind Datta, the senior counsel, and he was referring to the concurring judgment of Justice Vivian Bose in the case of State of West Bengal versus Anwar Ali Sarkar, where Justice Bose developed the concept of Article 14. This is one of the seminal judgments. So therefore, in a decadal wise, 50s, 60s, 70s, we can see how the trend, what is the trend in the judgments of the Supreme Court. So I don't want to say much on this. Justice Oak is with us. Undoubtedly, not only he is the senior most judge in the country right now, undoubtedly one of the finest judges. Judges come, judges go. Chief justices come, chief justices go. But when we look into the law reports, we feel good. There's a feel-good factor when we see a good judgment. A judgment which highlights the constitutional essence of liberty, democracy, human rights. Justice Oak, I'm sure many of you will agree, fits into the pantheon of those judges. He may not become the Chief Justice of India, doesn't matter, but he will always be remembered. Posterity will remember him as a champion of human rights and liberty. Thank you very much. Like you, I am also eager to listen to Justice Oak. Wish you a very good evening to all of you, and we hope that today's deliberation will be a very fruitful one. Thank you.
Thank you, Your Lordships, for your informative and highly thought-provoking speech. Your Lordships have rightly observed that we should develop a critical mindset and also critically analyze the jurisprudential value of judgments of the Supreme Court or any other court. It is with great honor and profound respect I now request our today's chief guest, Honorable Mr. Justice Abhay Srinivas Oak, Judge Supreme Court of India, to kindly share his invaluable knowledge and illuminate us with his words of wisdom on today's topic, Art of Advocacy and Duties of Advocates under the Constitution. Lordships.
My esteemed colleague in the Supreme Court, Justice Ujjal Bhuyan, the Chief Justice of Assam High Court, sister and brothers of the Assam High Court, the Advocate General of Assam, the President of the High Court Bar Association, senior advocates, members of the bar, and junior members of the bar who are present here in large numbers. The topic given to me is a mixture of two topics. First is duties of lawyer under the Constitution of India. And second is art of advocacy. There is a correlation between the two topics. As far as duties of lawyer under the Constitution, duties of an advocate under the Constitution are concerned, I can sum up in two sentences. One is follow professional ethics to the hilt, and second is always take a stand within four corners of law for upholding the Constitution of India. I always tell the members of the bar, especially young members of the bar, that please look at the first clause of Article 51A, which enjoins every citizen to abide by the Constitution and to respect the ideals under the Constitution. I believe that if ideals of our Constitution are to be protected, the members of the bar have to play a very important role. When we talk about taking a stand, in the bar function, my esteemed colleague Justice Ujjal Bhuyan referred to stand taken by bar associations in Maharashtra. They took a stand even to the extent of going that they do not have confidence in the integrity of 4 sitting judges of the Bombay High Court. There are instances and instances. I refer to Keshavananda Bharti judgment. Within few days of that judgment, 3 senior-most judges were superseded. On the very day in the morning, there was spontaneous reaction on the part of members of the bar. If I recollect correctly, former Chief Justice of Bombay High Court, MC Chagla, was the president of the Supreme Court Bar Association. Lawyers spontaneously met, the Bar Association met without calling a formal meeting, and they protested about the supersession. If independence of judiciary is to survive, it cannot survive without active role being played by the members of the bar. Of course, that responsibility lies on the judges also. As brother rightly put it, that we are final, not because we are always right, we sitting in the Supreme Court. And we are not infallible. And therefore you see the change of views between 1950 from A.K. Gopalan's case to Maneka Gandhi. We had travelled far ahead. And I always believe that if the independence of judiciary is to survive, we the judges also must accept our mistakes. One greatest example of institution accepting mistake, I must share with you. I'm sure some of you must have read that, especially senior members of the bar. It is again relating to Bombay High Court. As all of you know, Lokmanya Bal Gangadhar Tilak wrote 2 articles in one English newspaper and Marathi newspaper, of which he was editor, and he was tried for sedition before Justice Dawar. At that time there was a jury trial, and he defended himself. So he was assisted by a large number of lawyers, defended himself. And I implore young members of bar to read his defense speech. When somebody is tried for sedition today, even today that speech is very relevant. That's not the point today. Point is that Justice Dawar convicted Lokmanya Bal Gangadhar Tilak for transportation for 6 years. And then he was sent to Mandale, where he underwent entire punishment. British government did not release him, though during the period of incarceration his wife died. What happens in 1956 is very important, because birth centenary of Lokmanya Bal Gangadhar Tilak. Chief Justice MC Chagla held a function in historic room number 46, where the trial of Lokmanya Bal Gangadhar Tilak was conducted. And he publicly apologized by saying that it was a grave mistake committed by Justice Dawar for convicting a great patriot and somebody who advocated very strongly for freedom of speech and expression. And therefore, if you visit room number 46, outside room number 46, those famous words of Lokmanya Bal Gangadhar Tilak have been inscribed, where he said, when he was asked, when the jury said that by majority we hold that he is guilty, when Justice Dawar asked him, he said those magical words. He said that in spite of verdict of the jury, there are higher powers which rule the destiny of men and nations. And the cause which I represent may prosper more by my suffering than by my remaining free. So Justice M.C. Chagla, as Chief Justice of Bombay High Court, apologized to the citizens. Of course, as we have freedom of speech and expression, there were right-thinking people who criticized Justice Chagla. When High Court completed 100 years of its existence, one very eminent journalist who used to write about the judgments in Times of India and other leading newspapers was requested to write History of Bombay High Court. Those were the days when I also started practicing, those were days where the reports about the judgments delivered by the constitutional courts were not published on the same day. There were law reporters who used to go through the entire judgments. They used to cross-check all the references in the judgment, and after 2 or 3 days, they used to publish articles, very learned articles on the judgments. Now today, of course, when 10:30 Supreme Court pronounces the judgment, and our so-called experts are willing to discuss that judgment in the evening on television channel, though judgment runs into 4 or 5 different opinions and 1,000 pages. So that gentleman wrote a book in which he criticized Justice M.C. Chagla. He said Justice Chagla had no business to criticize Justice Dawar, because if you take into consideration the law which was prevailing at that time, Justice Dawar was fully justified in sentencing Lokmanya Tilak to undergo transportation. So these 2 events are very important. One, Chief Justice of Bombay High Court publicly apologizing, and the other, a fiercely independent journalist saying that Chief Justice is wrong. He did not say that Justice Dawar is right. He said that criticism is wrong. Now, gone are those days where there could be constructive criticism. One more fierce example of independence of a member of the bar, I remember. A judge of the Bombay High Court delivered certain lecture, a speech in one of the district places on the occasion of Lok Adalat. I am talking about way back 1986-87. Marathi version of Times of India wrote editorial severely criticizing that judge. It was purely constructive criticism. The editor referred to what the judge said and how he was wrong. And he also commented that when judge says something outside the court, he's just like any other ordinary citizen, and therefore he criticized. A division bench consisting of same judge or junior judge, they issued notice of criminal contempt to the editor. I was very new lawyer, just joined the High Court practice after practicing for 2 or 3 years in district court. The Bombay Bar Association and Advocates Association of Western India, 2 very powerful associations. And Advocates Association of Western India, the oldest bar association in India, they decided to intervene. And 2 very formidable seniors were engaged to argue in favor of dropping the contempt. I don't recollect what were the arguments. I was fairly new. I was not conversant in the nuances of law regarding contempt, but a team of about 10-11 over-enthusiastic juniors like me was constituted. And we were supposed to make research. Research was very difficult in those days because we had to go through all the commentaries, all the digests and the law reports. It was not on the fingertips. So arguments went on. 2 senior advocates who were appointed by the Bar Association. They argued vehemently. Somehow bench was not convinced. Then came the turn of Advocate General. I will tell who was the Advocate General. Advocate General was late Bhausaheb Bobde, father of Justice Bobde, former Chief Justice of India. And I could see exhibition of brilliant but fearless advocacy on his part. All the arguments were over. The judges asked, Mr. Advocate General, what you have to say? And he had brilliant idea of advocacy. Sometimes he used to take strategic calls. He used to never respond immediately. So he just looked at the judges and then he said, Sir, I don't want to say many things. First thing which I want to say is, your lordship should not be touchy about the criticism made against you. Secondly, he said that, sir, I feel very sorry that a division bench of Bombay High Court is saying that such criticism is a contempt, when I expected the senior judges to uphold the right of the editor to write that article. Two sentences he uttered and he sat down. The bench assembled in the afternoon and they said that we have dropped the contempt proceedings. Very fearless way of advocacy. I can give you several instances of fearless advocacy. But now I want to be on the other part of it. Before I want to be on fairness on the part of the advocates. Before I do that, I want to tell you only one or two instances where really advocates went wrong. Now, first and foremost is tendency on the part of members of the bar of boycotting the courts. Though there are judgments of the Supreme Court which hold that boycotting the court amounts to criminal contempt, still those things happen. I want to tell you a practical part of it. Let us take the case of a district court where there are 10 courts. In 10 courts, there will be at least 50 cases listed. So if you boycott the court, 10 multiplied by 50, 500 cases are given dates, litigants go back. What a huge loss to the system. But still it happens. As a judge of the Bombay High Court, I had to issue contempt notices to about 8 to 10 bar associations. And they boycotted the court proceedings for months together in demand of setting of the bench. Unfortunately, this trend followed when I went to Karnataka. I had to issue notice to over 6 or 7 bar associations. Same thing is happening in Supreme Court. I had to issue notices to, I think, one of the bar associations for Rajasthan, Jaipur Bar Association. And 75 years of existence of Constitution, why this is happening. And keep aside the contempt part. I talked about ideals of the Constitution. One of the most important ideals is that justice should be made available. Justice, social, economic and political. Now there can't be social and economic justice unless we are able to render quality justice to common man of this country. So whether judges, whether lawyers, all those who are part of legal system are duty bound to render justice to common man, justice to citizens of India. And if we are supposed to render justice, this boycott or skipping the court in protest does not find place in the Constitution at all. It is completely against the Constitution. One more instance which I had to deal with in Karnataka. There was a young student, some 20 years old, 21 years old. In one of the functions, one of the gatherings, she shouted something which people felt that it was anti-national. One or two sentences she said. She was taken into custody. She was a student of some undergraduate degree course. Shockingly, the local bar association passed a resolution that no lawyer will represent that particular girl. It was brought to my notice. I initiated suo motu contempt proceedings on the basis of the writ petition filed. The petition was filed before me by members of the bar. I told them that I am going to issue contempt notice to the bar association. But what manner you want to represent the cause? The members of the bar who were petitioners said, "Sir, we will go there and file a bail petition on behalf of that girl." They are all practicing in the High Court in Bangalore. I recorded that. They went to the court. The lawyers did not allow them to enter the court premises. Their cars were told to stop at a particular point of time. Then we had to pass an order, give them police protection. Let these lawyers go in police protection and file a bail petition. And eventually the bail petition was filed by those lawyers. So I admire the courage of those members of the bar who took up the cause against their own brother advocates in that particular district. Of course, later on, I issued contempt notice. The members of the bar apologized. They gave undertaking that they will never do it. I mean, this is completely against the ethos of our Constitution. Can members of the bar say that a particular accused should not get a lawyer? This is completely in contravention of Article 21. But surprisingly, these are the things which happen. And as courts, sometimes we have to be very strong. We are not happy to issue contempt notices to the members of the bar. But unless we take that extreme step, we won't be able to enforce the obligations of the members of the bar under our Constitution. Now coming to the professional ethics, I consider myself to be very fortunate that there were senior members of the bar around me when I started practicing, from whom, without telling me what fairness means. I could learn the lessons of fairness. As a junior lawyer, a client came to me. He was owner of a vehicle involved in the accident, and it was a claim petition filed under the Motor Vehicles Act. And the injured had suffered fracture of 2 bones of his left leg, and the length of the leg was shortened because of that. There were medical certificates, and he was limping. That was very, very clear. Now, actually, my job was very simple because the claim was covered by insurance company. So therefore, I had a free hand. I mean, it's a process of learning to cross-examine. I started cross-examining. I gave a suggestion that I put it to you that you have not suffered any disability whatsoever. So one senior member of the bar was sitting there. Afternoon he called me. He said, never do that. You are also a human being. You know that this man has suffered disability. Your cross-examination should be to bring on record the percentage of disability. If he has claimed that he has suffered 50% disability, consider it on showing to the court it may not be 50%, it may be less than 50%. But don't be so inhuman. When you know that this man is limping, and don't give him suggestion that you are not suffered any disability. One more classic case. We had a very renowned lawyer practicing on the appellate side of the Bombay High Court. He was known for his fairness, and he was so fair. In those days, even in my practice days, second appeal, is very important litigation for all of us. Litigation of common man. So his reputation was, unless he himself was convinced that there was a substantial question of law involved, he would never argue a second appeal. He used to file it and stand up before the court. And his reputation was so high that some judges found that this man, this lawyer utters 1 or 2 sentences, they used to just frame substantial question of law and admit appeals. That was his reputation. So I was a junior member of the bar. I had not argued a second appeal. So I reached the bar room where I used to sit. I received a call from my senior. In those days, mobile phones were not there. The bar association office, I received a call. He said that he was feeling very unwell. He has fever. And he said that he has told 2 other juniors to mention matters for adjournment, but there is one second appeal before a very great judge of Bombay High Court. And we are respondents, so go ahead and argue that appeal. But I said, sir, I don't have the file. He said, no, file is there on my table. I think it is down below in the causeway, so go ahead and read the matter. So I took out that file, was sitting in the court waiting for my turn to come. The senior lawyer whom I referred, very fair lawyer, I was not aware that he is so fair. He was sitting next to me. In those days, Bombay High Court, there was no air conditioning. And because of sudden pressure, I was really perspiring. I never knew how to argue second appeal. I was just glancing through pages. So then suddenly I remembered that it was some issue regarding Hindu law. And we had that beautiful law report, Bombay Law Reporter. So there was one old judgment of 1929 or 30 on some issue of Hindu law. I forget what was the issue. So I thought that the judgment will apply. So I rushed to the library. I got the book. I gave a citation to the court Sirastedar, so that he could call book from the judge's library. So I was sitting there, wiping my face. The senior lawyer was sitting, he was supposed to have your opponent. He said, "Hey, young man, can I see that book?" I thought that this is my trump card and my opponent wants me to see that book. I reluctantly handed out the book. And then ultimately case was called out. He told judge, Justice S.K. Desai, very, very tough judge. Juniors had to be very well prepared to appear before him. He said, "Sir, I must tell you that this issue is clearly covered against me by judgment of our court, and fortunately this young man is carrying that judgment with him." Matter was over within 2 minutes. When we came out in the corridor, he said, "Arey, I know what must be passing in your mind, that you had trump card in your hand. I took that book for a different reason. I wanted to ensure that you have got the correct judgment." So that was the standard of fairness. See, ultimately, for the benefit of young members of the bar, I want to divulge one secret. See, when we sit on the dais, we are very lonely, and we prefer fair lawyers because we want that kind of assurance. So perhaps fair lawyers get better hearing in our courts. We want a lawyer who will tell us that, sir, prima facie, the issue which I am conversing is covered by judgment of this court, but I want to distinguish that judgment. So a fair lawyer is always welcomed by the judges. And why this fairness? Why fairness is required? The fairness is required for the simple reason that lawyers are integral part of our justice delivery system. And it is because of the lawyers that we are able to lay down the correct law. It is duty of the lawyer to ensure that justice is done in accordance with law. And fairness is required for one more reason. That as a lawyer, you have to be honest to the court. And therefore, if some facts are against you, please point out to the judge what is against you. And then argue that these facts will not ultimately affect the final decision. If all of us want to ensure that common man gets justice, common man will not get justice unless the lawyers are very fair. And I always believe that fairness pays in the long run. Maybe sometimes you will feel that because you are fair, you lost a case. But in the longer run, it will pay. How the mind of judge works, we know a lawyer, a fair lawyer appears before us, a young lawyer. He says, sir, this is covered. Prima facie, this is covered against me by a judgment. Then the lawyer would try to distinguish. Then we as judges, we are also human beings. And our mind will also work to find out whether there is some way out. This man is very fairly telling that his case is covered against him. Then we also try to find out some way out, whether some limited relief can be granted notwithstanding a binding judgment. So fairness always pays. One more part of advocacy on which I think I must elaborate. I think the members of the bar are now forgetting that brevity is hallmark of great advocacy. Of course, that is applicable to judges also. That our judgments must have quality of brevity. That applies to judges also. Both sides, perhaps we are forgetting the importance of brevity. The pleadings, it starts with pleadings. Now pleadings have to be very precise. Maybe when I started practicing, our seniors expected us to write down, to make a written draft of plaint or written statement or a petition under Article 227. And when you write it down by hand, you have to be brief and precise. You can't keep on writing pages after the pages. In fact, I remember as junior lawyers, our seniors used to prohibit us from dictating a draft to a stenographer. They always felt that we must write it down. But now, technology is very useful in our justice delivery system, but technology sometimes can be harmful. Now we do cutting and pasting job by drafting a plaint or drafting a petition. Therefore, our pleadings become very verbose. The law is very clear that you should never plead law, but we plead law. In the counter affidavits filed before the High Court, now we cite judgments, we quote the paragraphs after paragraphs of the judgment. So, the quality of brevity we are forgetting. And this tendency to cite large number of precedents, because they are available now. If there is a direct judgment of the Supreme Court on a particular issue, why you need to cite 4 or 5 judgments of the parent High Court on the same issue, or 10 judgments of other High Courts on the same issue? What is happening is now there is some kind of a competition. People want to show to the litigant that how much effort he has put in, and therefore the moment case is called out, especially in High Court and Supreme Court, he would hand over a compilation of judgments just to show that he is very well prepared. That is harming the judicial system. In fact, one of the judgments under Arbitration Act, I said something about arbitration that will apply to many other category of cases. I said that in India, arbitrations have become synonymous with verbose pleadings, verbose arguments, lengthy awards and lengthy judgments. It is true that we the judges also have forgotten to some extent that brevity is hallmark of a great judgeship. But sometimes why lengthy judgments are required to be written? If you go and argue an appeal before a district judge and place before him some 20, 25, 30 decisions, the judgment becomes lengthy because he has to refer to all the judgments. Because a district judge will always feel that somebody will find fault. In High Court, same lawyer will get up and say, sir, I had cited about 25 decisions, but the judge has not referred to it. Therefore, there is a tendency to write long judgments. Now, this is one area where I think we are going wrong. Some of the amendments to the law also have contributed to it. Classic example, I tell you, the amendment to Order 18, when in civil courts, now we are permitted to file affidavits in lieu of examination in chief. When such affidavits are filed, when I read such affidavits, I always apply my mind and possibly imagine what would have happened if the witness would have, his evidence would have been recorded, examination chief would have been recorded in the open court. Now because we are permitted to file affidavits, we file very bulky affidavits in lieu of examination chief, running into pages. In city like Bombay and many metropolitan cities, it happens in section 138 complaints. There also there is an amendment. The affidavit in lieu of examination chief of complaint can be filed. Now sometimes the complaint runs into 10 pages, but affidavit in lieu of examination chief of complaint runs into 30 pages, 40 pages. So this is one provision of filing affidavits in lieu of examination chief is turning out to be counterproductive. I am not finding fault with the legislature. I am finding fault with those who are implementing it. When we judges also, we must be also telling the lawyers that this is not done. Why want very lengthy affidavits in lieu of examination chief? Now these are the simple causes for prolonging the trials. One more area where now we find, especially in criminal cases, there is very lengthy cross-examination. In November or December, we came across a case where we found that a defense lawyer had cross-examined a witness, say for half an hour or 1 hour every day, for 95 days, 95 different days. And the cross-examination ran into some 55, 60 pages. And when we read the cross-examination, we found that hardly anything relevant. The art of cross-examination is a forgotten art now. Now what is happening in criminal trials is, every sentence which is uttered in examination chief, the cross-examiner will say, I put it to you that this is wrong or this is false. It's not necessary. And in this lengthy cross-examination, the basic cross-examination about bringing on record the contradictions and omissions, we forget that. Or sometimes the cross-examination is so bulky, in the Supreme Court it takes time to find out which is the relevant part. Which is the relevant part where his witness is confronted with his prior statements and omissions and contradictions are brought on record. So therefore, when it comes to the professional ethics, the fairness is the most integral part of the professional ethics. And I want to again tell, for the sake of repetition, for benefit of young members of bar, that fairness always pays. Therefore, to conclude, professional ethics is not something which is written in the rules framed by the Bar Council, the State Bar Council or Bar Council of India. These rules are essential for ensuring that the lawyers are able to contribute to the justice delivery system. Because only if you follow the rules of ethics very strictly, in that case, you will be able to assist the court very effectively. all the great judgments, brother talked about Keshavananda Bharati. But for effort made by the lawyers, you would not have got those judgments. I gave example of emergency. In so many states, very distinguished lawyers filed petitions of habeas corpus for challenging the detention under that old act NISA. They succeeded or they failed, that's a different thing. But they showed highest degree of professional ethics and professional commitment and took up the causes. And last thing, my appeal to all young members of the bar is to work pro bono in legal aid cases. It's very, very important that all of you take up the legal aid cases. In fact, other day I was speaking to a gathering of lawyers in Bangalore. I said now time has come when we should make it compulsory for every designated senior advocate practicing in the High Court to appear at least in 5 criminal appeals where the accused cannot afford to engage a lawyer. 5 criminal appeals per year, and same rule should apply to the senior lawyers appearing in our trial courts, that they must do some pro bono work. There are many serious cases on the criminal side where perhaps junior or inexperienced lawyer appears and there is no proper cross-examination. And ultimately, if there is no proper cross-examination, it affects the right of the accused under Article 21. I always believe that legal practice is a 5-star social work, in the sense that if you are successful, you can earn a lot by practicing before the courts, but at the same time, you can do a lot of pro bono work and help poor people to agitate their grievances before the court. The last thing, I am really glad that Assam unit of Indian Law Institute is working and working efficiently, because in most of the states, the units of Indian Law Institute have become defunct. I just want to give one suggestion. Maharashtra Bar Council of Maharashtra and Goa, they conduct training courses for junior lawyers, that is known as CLEP, Continuous Legal Education Program. Now, the chapter of Indian Law Institute can start conducting such courses for junior lawyers, for beginners, the junior lawyers, because they need legal education. They need to be told the few concepts of art of advocacy. We must train them how to draft pleadings, how to conduct themselves in the court. We need to train them in basic discipline, that when one lawyer is arguing, he is not supposed to interrupt. He has to show a lot of patience in the court. So, through the medium of Indian Law Institute, we can start training courses for young lawyers. Fortunately, in our country, and I'm sure about state of Assam also, there are many distinguished retired judicial officers, senior lawyers who will be willing to teach the young lawyers. So I thank the organizers for giving me this opportunity to have dialogue with all of you. So many young lawyers are standing here. I'm really glad that they have come in such large numbers. And especially to young members of the bar, I wish a great success, and I hope and trust that you will become instruments of change and you will be able to render quality justice to common man. Thank you.
Thank you, Your Lordships, for delivering such an insightful and intellectually engaging oration. Your Lordship's profound wisdom has truly enriched our understanding and importance of values like fairness and fearlessness in advocacy. We are deeply grateful for the time and effort Your Lordships have taken to share your invaluable knowledge and experience with us today. Your words and suggestions will undoubtedly serve as a guiding light for all of us in the legal fraternity. May I now request Honorable Mr. Justice Sumitra Soikia, Judge, Gauhati High Court, to kindly deliver the vote of thanks.
Honorable Mr. Justice Abhay Srinivas,
Judge, Gauhati, Supreme Court of India, Honorable Mr. Justice Ujjal Bhuyan, Judge, Supreme Court of India, Honorable Mr. Justice Vijay, Honorable the Chief Justice of the Gauhati High Court, Honorable Judges of the Gauhati High Court present in the meeting today, Mr. Gajanan Saiwala, Senior Advocate, Secretary of LiveLaw, Mr. Hemanto Kumar Korma, Advocate, Joint Secretary, LiveLaw, Mr. Kamal Agarwal, Senior Advocate, Treasurer, Indian Law Institute, Assam State Unit, respected learned members of the Indian Law Institute, Assam State Unit, Justice Mir Alfaz Ali, Director, Judicial Academy, present here, Professor Dr. Sharma, Vice Chancellor, National University, Assam, other members of the Academy are present, Registrar General and members of the Registry of the Gauhati High Court, members and office bearers of the Gauhati High Court Bar Association and Gauhati High Court Advocates Association, senior advocates present, Advocate General Assam, law clerks, law interns, law students present, ladies and gentlemen. It is indeed both an honor and a privilege to extend a vote of thanks on behalf of the Indian Law Institute, Assam State Unit. At the outset, I express my deepest gratitude to our Chief Guest, Honorable Mr. Justice Abhay for gracing this occasion with his esteemed presence and the delivery of an insightful and thought-provoking lecture on the topic of duty of advocates under the Constitution of India and the art of advocacy. Your erudition and clarity of thought have enriched our understanding of the subject, offering new perspectives that will inspire the members of the legal fraternity and the judiciary alike. We are extremely grateful to your Lordship for taking out time of your Lordship's extremely busy schedule to grace us with your presence for this occasion and for sharing with us your vast knowledge and experience. I offer my sincere thanks to Honorable Mr. Justice Ujjal Bhuyan, Judge, Supreme Court of India, for his presence today at the request of the Assam unit of the ILI and for his introduction of our chief guest for today's function. We are indeed grateful to His Lordship for taking out time of your Lordship's busy schedule and accepting our invitation to be present in this August gathering, August function as a special guest of honor. A special thanks to Honorable Mr. Justice Vijay Bishnoi, Honorable the Chief Justice, the Gauhati High Court and President of Indian Law Institute Assam Unit for His Lordship's continued guidance and permitting us to hold this function today. Honorable the Chief Justice has been the beacon of the Indian Law Institute Assam Unit, and under his able guidance, this program could be successfully organized. I would also like to extend heartfelt thanks to all the distinguished guests for their kind presence and participation. Your support and encouragement have always been invaluable. We are grateful for your continued presence and support. We are grateful to the organizers, members and office bearers of the Gauhati Town Club for giving us this hall and auditorium with all the facilities to hold this meeting today. My sincere thanks to the Indian Law Institute Assam Unit and the members and the volunteers who have worked tirelessly behind the scenes to make this event a grand success. Your dedication and hard work are truly commendable. I would like to thank each one of you in the audience for your active participation and enthusiasm. Your presence has made this event even more special. Special thanks to Joba Ratna Thakur, advocate, for gracefully anchoring this event. Once again, thank you all for being here and making this event a memorable one. We look forward to your continued support and participation in our future endeavors. Wishing you a very good evening ahead and my good wishes for the festival of Holi ahead. Thank you. Jai Hind. Namaskar.
We extend our deepest gratitude to Honorable Mr. Justice Sumitra Saikya, Judge, Gauhati High Court, for delivering a heartfelt and articulate vote of thanks. Your words have aptly captured our collective gratitude to our esteemed dignitaries, our distinguished guests, and everyone present here today. With the inspiring words of gratitude just delivered by His Lordships, we now come to the conclusion of this memorable event. On behalf of Indian Law Institute Assam Unit, I, Ms. Jawaharlatna Thakur, Advocate Gauhati High Court, extend my heartfelt appreciation to all our esteemed dignitaries, distinguished guests, and one and all for gracing this event with their kind presence. Today has been a remarkable gathering of wisdom, knowledge, and shared commitment to advancement of legal education and research. As we depart, let us carry forward the insights and inspiration gained here and continue to contribute meaningfully to our respective fields. Once again, thank you all for being part of this occasion. Wishing you a pleasant evening. Thank you. Requesting everyone to proceed for high tea. Thank you.